Thank you for joining us. If you're a veteran struggling to get the benefits you deserve, you can always get a free case evaluation from our team at Hill & Ponton by clicking the link in the description or in the comments. That link will take you to our free case evaluation, which will help us find out whether or not we can help you with what you're struggling with. And for those of you here just to ask questions and get them answered, we're going to get to your questions in order that they came in. We use a different software, so if you don't see the question on YouTube, we more than likely will see it on StreamYard, the software that we use to put the questions up on the screen for our attorneys to answer and for you to read. Thank you so much for joining us, and we hope you have a wonderful day. Now it's time for the attorneys to take over and start answering all your questions. Enjoy.
Good afternoon. Welcome to another Q&A Live with Matt Hill and Carol Ponton. A little blurry here, not really sure what's going on, but hopefully that'll come into play. We wish you a belated happy Veterans Day to all y'all out there. Thank you for your service. We hope that today will be fruitful in answering the questions that y'all have. So let's just jump right in today. Sure, what's going on there? All right, Mickadoodle. Hi, thanks for all you do. Have a 60% disability in my hands due to rheumatoid arthritis. I'm 100% PNT. Was denied SMC. What is loss of use of both hands? Thank you so much. This is Carol's. This is top 5 favorite questions for her.
Yeah, I love it when you get loss of use because you get so much more money from the VA. Loss of use of hands is when you can't use your hands to do things that you need to keep yourself safe and healthy, like getting dressed, buttoning your shirt, zipping your pants. One of the tests they use is, can you pick up a coin off the center of the table? Not sliding it to the side, but pick it up off the center. So basically what you have to show is because of a service-connected problem, rheumatoid arthritis, you can't use your hands. And I think that's something that you should make a statement about all of the problems you have with holding a fork, using a pen, trying to type, anything that you use during the day, and then have a witness, 1 or 2 witness statements talking about what they observe, or they have to help you because of those problems. So remember, you also may need aid and attendance. I love these SMCs. You may need aid and attendance because you're not able to take care of yourself because of the problem with your hands. What if you can't shave? You can't brush your teeth. You can't get dressed. You can't cook. You can't cut your things with a fork or a knife. So remember, you may be needing to file for aid and attendance due to the limitations from your hands as well. But remember, you have to show it's due to a service-connected problem and how it affects you in being safe, taking showers, getting clean, watching out for things that are burning because you can't feel them, safe and healthy. Go for it. I love SMC.
If you're talking about loss of use of both hands, that's SMCM, isn't it?
I don't remember it.
It's more higher than SMCL. But one of the things I tell veterans when they're talking about loss of use of hands, I've seen veterans get very creative on how they do things. So like one of the things is, can you use your fork? Can you eat your, cut your food? And I've seen vets who, would normally hold a fork proper way, kind of try to manhandle it to be able to manage it. So just make sure that, you think back to how you used to do things versus how you have to do them now modified. And I agree with Carol, not only your statement, but at least one other person. Right. Zeb, good afternoon. My appeal was remanded. I had a CMP exam. Does it go back or judged to be granted or denied? If it was remanded from the BVA and they asked for a CMP exam, then the regional office or the DROC in this situation will make a decision. To get back to the Board of Veterans Appeals, you have to actually appeal it back to them. It used to be it would automatically go right back to them. It doesn't happen anymore. These are the cases that are routinely denied because the RO denied it in the first place. Oh. So just make sure that you do file that appeal back to the board if it does get denied. John Johnson, could you tell me what is an addendum medical opinion the BVA requested in a new exam? BVA said it was an error. An addendum would be an addition to the original medical opinion, probably sent to the same examiner, either asking additional questions or clarifying questions or saying, hey, you didn't answer the question we asked you in the first part. Hard to tell whether it's positive or negative. The only way really to find out would be to look at the original opinion. You go ask for a copy of that original DBQ that they filled out to see what it said.
It says there, he says, the BVA request a new examiner.
A new examiner.
Yeah, a lot of times they're not happy with the exam. Maybe they feel like the person was qualified. And so in that case, they would ask for a new examiner. So the new examiner, it looks like they're just going to review what happened and make another opinion. Unfortunately, a lot of times you would rather them go ahead and do the whole exam so that they can find out maybe information that the first examiner didn't provide.
Yeah. Timothy, submitted an increase for migraines, received a notification that I would have a record review, ACE exam. How successful are these exams? I submitted evidence that line up with a 50% rating. I mean, it's a crapshoot. There's no way to tell one way or another. Now, you said you set evidence for a 50% rating. Realize that this is above and beyond how frequent, how painful the migraines themselves are. You need to show proof of it interfering with your ability to work. Either you're constantly missing days of work, or you're missing half days, or it's unpredictable when you can work or can't work. So just make sure that that is what you're submitting and focusing on, not just the migraines themselves. You have to be above and beyond the frequency of the migraines here.
And what we do is we ask the veterans to complete a headache diary. It lasts 30 days, and we ask every time they have a headache that they write the date, the time, how long it lasts, and what they had to do. And for instance, a lot of my clients will say, I had to leave work. And I had one, he had to leave work 3 times in 1 month. You can't hold a job if you're leaving work that often. And that's how you prove the, he also put, I couldn't concentrate. I had to be in a cold, dark room. And that's how you show that this is interfering with your economic productivity.
ACS soccer highlights. How would VA order 2 medical opinion record reviews only when I still have 1 pending C&P exam for my neck? This is my 2nd supplemental claim for my neck, mental health, migraines, and TDIU. Thanks.
Well, they need a medical opinion for each one of those conditions, and that's probably what they're doing. Especially TDIU is a totally different one. And so for each one of these, for your neck, for mental health, for migraines, they're going to be asking the examiner, how do these problems interfere with your ability to work? So there probably will be 3 medical opinions.
Yeah, and the frustrating thing here is there's no umbrella medical examiner that says, how do these 3 interact to prevent you from working? So they all look in their individual silos. Okay, this is what mental health does. This is what migraines do. This is what neck does. Nobody's adding it all up.
And so then they deny you, saying, this person said you could do that. This person said you could do that. And they don't put it together. And that's why you would file a higher level review asking from them to put all of it together. When you combine it together, then you can't work. But a VEO opinion, a vocational expert opinion, is not that expensive, and they don't order them. So if you have one, the board is likely to grant it. The regional office may not, but the board is likely to grant it because there's no other evidence.
You can look online to find vocational experts. And the beauty of this is you're using the VA's own facts against them. So what we would do is, if we hired a vocational expert, you had these 3 exams, we would submit them to the vocational expert. We'd say, okay, based on the veteran's past work history and education, what kind of jobs would they be eligible for? And then we'd have the vocational expert graft over that the restrictions that the VA lists and say, what, with these restrictions, which of these jobs they could do. It's a really powerful opinion. Frankly, the VA should be doing these kind of things, but they don't. So I'd look for somebody online if you get there.
Knock on wood, we've never lost when we had a VEO.
She always does that.
I'm just saying that's how powerful.
We'll lose 3.
That's how powerful they are. So get one.
Another step. Good to see you. 1 of 2. I have recently been diagnosed with hypertension by my civilian primary care physician. I have documented high blood pressure readings while on active duty in the VA at the VA over the past 10 years, but was never diagnosed. I think it's important for hypertension to be service connected at any rating. We agree.
I agree.
Do I have enough to file a claim? What other information, documentation do I need? Are there any other options? So remember, to prove a claim, you have to have a current diagnosis, something happened in service, and then a nexus, a connection between the 2. You do not have to have a diagnosis in service. This is one VA loves to say, oh, you didn't have a diagnosis of hypertension in service. That's not the requirement. You just have to point to something saying, look, something was going on. Here you have high blood pressure readings. So file the claim. They're gonna send you a C&P exam, probably deny you because they're gonna say you didn't have a hypertension, and then you're gonna need to go out and get either this primary care doctor or somebody else to give you an opinion showing that nexus.
I have reviewed the service medical records, and the blood pressure readings were I find that in service, you did have hypertension. It has continued today. You still have hypertension.
Or what happened in services was indicative of causing the hypertension now, something like that. But back to your original point, we completely agree. Unfortunately, hypertension is like a gateway disease. I mean, it causes so many secondary problems. You know, even if you get service connected, it can be 0% or 10%, but it's very much worth doing that now, because if you develop some kind of secondary problem due to that hypertensive heart disease, stroke, in anything, you want to already have that service connected so that you get those benefits quickly.
And the other way, if you do want to get a 10%, because that's basically all people can get unless they are really, really should be in a hospital with their high blood pressure, is you're supposed to show what your readings were, the highest readings were before you got on medicine or when you were first diagnosed with it. And the problem is the VA is going to take readings when you go to the exam while you're on high blood pressure medication. So it's not going to show that. So if you have a way to find out, I guess, your service medical records, if they were really high or ones where you were early on, get those and make sure they're put into your record and pointed out to the VA. But like Matt said, hypertension is the gift that never stops giving. It unfortunately can cause horrible strokes, hypertensive heart disease, chronic kidney disease, all sorts of things. So if you have a chance, get service connected before. Hopefully you don't have them, but if you do, then that's going to be a really easy way to get all of those problems covered.
John Johnson, what form do I need for the BVA evidence lane? Oh, man.
God, I think I never look at the numbers anymore.
If you look, when you get your decision on the last page, it has all the different appeals that you can file.
There's only one appeal for the
BVA.
BVA, and on that you check direct evidence or hearing. Okay, so if you have that one, I think 1096 is the 096 is for higher level review. So I'm 0997. I don't really
Don't
remember
trust us on that one.
Yeah,
look up. JG, is the BVA granting SMCK at the RO after the Alaska decision? I have a pending supplemental because the VA previously removed my favorable findings, granting me entitlement to ANA based TPI and a half. So just to kind of what BVA does, that the BVA, what the RO does is the RO. They don't make decisions for each other. Are they granting it? It's kind of too soon to see. I mean, they should be, but the evidence is on your side now. And so, you know, unfortunately we count on them making mistakes a lot of times. And so if they do that, whatever they make the decision on, you don't care. You just go straight to the board. I mean, the fact that they're trying to get rid of your ANA is ridiculous. Again, we fight a ton of these. It's just one where they don't want to give that kind of money away. So we do have to take a lot of these to the board. So, you know, if that's your road to hoe, then you got to do that. But you deserve these benefits, so make sure you fight for them.
and this is infuriating. I'm seeing this a lot with my cases. People will have been granted aid and attendance, and then they want to sever it because they say there's not one condition that causes 100% disability rating. No, but they have unemployability, which is 100%. And so they're taking what they have decided is the law. It's not the law. And they're using this to sever all. I've got like 3 of these going down. And so remember, the BVA is going to know this is wrong, but you just need to make sure you continue to appeal this. Okay.
Yeah, they're playing the odds.
Yeah.
You know, if you look at the statistics, people don't appeal. Only 4% appeal to the board. You know, think about all the money they get to keep of your money, of other veterans, if you don't appeal. So keep fighting. You need somebody to help you, give us a call. But otherwise, it sounds like you have the evidence there. You just need somebody who's going to make, follow the damn law.
And remember, SMT is a lot of money, $10,500 a month, and the VA is going to be very hesitant to give it. Right now, you're talking about a new case that came out. We really haven't had time for the BVA to actually get cases up there that relate to that. There's just a lot. I would say it's probably going to be a year before
Yeah, I
we
mean,
see
the
whether
action is first at the board,
right?
And then it trickles down to the RO. So that, I mean, you do have some. I mean, there's good people at the RO, and you'll have somebody who actually take the time to go look at case law, but that's not the norm.
No. Normally, when we used to have conferences, they'd say, "I don't want to hear about the case law. Why should I care what the law is?"
Right. Gene, hi, my lawyers, Hill and Ponton, submitted new evidence to the BVA on August 24th. Just wondering how long that normally takes. Thanks.
It all depends on who gets the case, what level it is. always new claims seem to be done within 6 to 7 months.
Yeah.
Okay. And then you get the appeals that seem to sit there. And that's, if they can deny, it usually goes quicker.
Yeah.
If they can't, then if they look at it and say, I don't think I can deny it, they
gotta
order a
develop it.
CMP
Right.
exam. So that's the problem. Anytime you put in good evidence, they're going to order a CMP exam. We call it develop to deny, but that's what they do.
And your case went in just before the end of the year. And so at the end of the year, they do the sprint to try to, make their stats look better by finishing up as many old claims as possible. So unfortunately, there's a little bit extra delay built in there.
So the end of the year was September 20th.
Oh, sorry. Yeah.
So yours probably came in before they were able to get to it. We find that after September 20th, the 30th, the end of their calendar year, things seem to sit there. October, November seem to be very slow, both for the regional office and the BDA, because they probably had to work overtime before, and now they're taking time off. So I'm telling you, always the end of the year slows down.
End of our year.
End of our calendar year.
Lonnie, how likely the regional office will grant half-step whole SMC increases due to Barry? Again, this is a new case, wonderful case. Carol is killing it on all our old cases, getting BBA to implement these. But as I said, BBA,
right?
Again, new case. They follow their little book, their little M21 manual, and if there's something not in that book, they're like, bunnies. They're afraid to go look for it. They're not going to do up and on. So I don't know that this has been added to their little book yet, but
I'm not seeing it yet.
This is the law. So again, if you don't get those benefits you deserve at the RO, you got to take it to the board. And trust me, I understand the frustration of waiting for the board to get what you deserve, but get what you deserve.
Since the Barry case, I filed a lot of those asking for a higher rating, higher SMC rating. I don't think I've gotten many decisions yet. And this is at the regional office. They're all going to the board if I don't get that.
SMC confuses the RO. They don't see it. I mean, for us, it's such a big part of our practice. And so we're really used to it and reversed in it. Most raters, once you talk about getting above 100%, they get scared.
They don't really understand.
And I mean, this is kind of complicated. You're talking full step, half step. You've already got SMC. So count on them getting it wrong, but don't let that influence you in what you do to get your benefits. Okay.
Right.
Remy 86, good to see you. VA denied, then closed my higher level review without giving me an informal conference, which I asked for. What should I do next? Oof.
I think you
can't do a car on that.
No, you have to file a supplemental claim saying there was failure to the duty to assist. They had to give you a conference. They didn't. I'll tell you what they do, because you can see the notes. A lot of times they will call you on Saturday or on Sunday or at 8 o'clock at night when you wouldn't answer the phone because you think this is
Solicitor.
A solicitor or a prank call. And they say, tried to call the veteran, couldn't get a hold of them, denied. So that's a big trick. A lot of them just don't do it.
Yeah. And the other thing that I would say here is maybe there's writing on the wall. I mean, if they didn't give that to you, if you file a claim and wait 6 months for them to give you one of these hearings, are you really going to get a sympathetic ear? That's what I would wonder. I mean, it might be worth it because 6 months is a lot shorter than applying to the board and waiting 3 years, but just understand that.
If you have really good evidence, if it's really something like an earlier effective date that they clearly should have awarded, then I would
go for the higher level.
Unless you're 75 or older and I can get a motion to advance to the docket. I'm going to the board now. Now that anybody that I can advance in the docket, I'm going to the board because they'll be done within 6 months.
Yeah. And you got a better adjudicate.
Yeah.
Michael LeMay, I received a granted judgment after 2 years for migraines. How long will it take for the remand and decision? Also, does this mean the regional office can any percentage they want, can give any percentage they want? God, tell them you see.
Okay, if it's a remand, they didn't grant. If it's a grant, the BVA either is granting you service connection or migraines, and in that case, the regional office will decide what the rating will be and what the effective date will be. If it's a remand, then they haven't granted anything.
I think we're talking about grant here.
Okay.
So it's going back, has to have a CMP exam. What happens sometimes is they give you an initial rating before the exam.
So maybe a 0.
And then they give you the exam, and then they'll say, as of the date of the exam, you are 10%, 30%. So what you want to make sure is that you get whatever you feel you're entitled to on the percentage, and make sure they take it all the way back to when you first applied. That's another way VA likes to take your money.
And it's very confusing because they'll say 0%, but we're going to send you out for a C&P exam. Okay. And what they mean by that is then we'll see what you are as of now. So you really need to appeal that initial rating you get if it's not 50% or what you're looking for. And if it's, remember, the other thing they love to do is, this has been going on for 2 years, they like to grant you benefits as of the date of the rating decision, or maybe the month before. This is, I've had 30 to 40% of my cases, that's what I see. So you want to look at appealing the earlier effective date if needed and the rating. You have to appeal both. You can't just appeal one if it needs to be appealed.
D-Dog D. Just got 100% permanent total with household. What is the limitations on housebound? Excuse me, housebound. What are the limitations?
Well, the problem is it's very confusing. Housebound is SMCS, and it can mean that you have 100% for one thing and a combined rating of 60 of the other, or it can be that you can't leave the house. And the problem is they don't differentiate when they talk about that a lot of times. You have to actually look at the decision, and it will say in the decision, housebound, not allowed to leave the house. So if that's the case, they mean that you can't leave the house except for exigent circumstances. Go to the hospital.
You can go get groceries. Like you can do basic needs. Yeah, you can do your basic needs. You can't go clubbing, can't go to the bar, can't go hang out social with friends, but the basic needs of what you need to do.
It should be very limited ability to leave.
But as Carol said, if it's SMC statutory based on you have 100% for TDIU for one thing and 60% for kind of others, there are no limitations at all.
Right.
So it's important here to look at your rating decision and see what it says.
And it will say in there you have 100% for whatever and then a combined rating of whatever. And that's the one where you can go and do whatever you want. Otherwise, it should say, because of a service-connected problem, you're unable to leave the house. So that should be in your decision. Once again, the rating sheet is always really good to get, because the rating sheet, code sheet, it says at the bottom, SMCS, and then it will say exactly what it's for.
In your file, the code sheet is attached to your rating decision. They never send it to you, though, because why would they send you something with that much information? That's really good to know.
Helpful.
So you need to request it. We always request a copy of that, because frankly, it's like that's the actual numbers and percentages and effective dates versus the rating decision is, it's not, to me, as informative or as interesting.
And another thing that's very important.
She just put her finger up.
That's right. Another thing that's very important is on that rating sheet, it will show you the code sheet. It will show you which part of their rating book they use to determine what the rating should be. So remember, sometimes they don't have in their book exactly what your disease or problem is. So they pick something they think is similar. Well, they could pick something that's similar that gives you a low rating, or they could pick something similar that would give you a higher rating. So they will say just before, say, back, they will have a code number on it. And you look up that code number and you'll see exactly what they used in order to give you the rating. And you should always look at that, because they often are wrong.
It's the diagnostic code.
Yeah.
So we talk about that a lot here. But it's incredibly informative. It frankly shows the history of any and every claim you filed that's not service connected and that is service connected, the effective dates, the dates of any change of more significant rating. There's a lot to go off there.
The other thing they show, which I just saw in a case yesterday, was whether they drop or change ratings you're entitled to. I had a veteran who had SMCS for the combined rating back to 2017. He got a rating, it was all the same, and then he got another decision that had nothing to do with SMCS or any of that, and they changed the rating to 2021. Just other times I've seen where they just drop tinnitus. It's just gone. He had 10%, and now it's just not on the rating, a code sheet anymore. So you always need to watch. This happens a lot more than you would think.
A lot more than it should.
Yeah.
All right. Yolanda Fergie Adams, 1 of 4, denied secondary service connection for FSD, secondary to PTSD, and ITP thrombocytopenia, secondary to Sjogren's. FSD favorable, CMP found FSD, PTSD, service-connected toxic exposure, yet still denied it. ITP favorable plus toxic exposure, C&P found ITP evidence showed qualifying event, injury onset during service, primary disability, PTSD. Should be Sjogren's. Should this be HLR, or do I submit supplemental medical records showing ITP as secondary Sjogren's as an interstitial lung disease, rated 50% plus plantus, 10% right knee, denied left knee, September, significant deterioration to point, could barely walk, diagnosed with bilateral tricompartmental osteoarthritis. Would this be a new claim for increase or supplemental? And if I can barely walk, do I qualify for SMCK? Whew, there's a lot going on here. So let's go back, I think, to the second one was the first question. Carol, I'd file for higher level.
So would I.
You have those favorable findings in the C&P. Sounds like you got a copy of C&P. Good on you. Okay, again, knowledge is power here. Take that, highlight it. I would write out in the appeal just a quick note saying C&P doctor said X, found nexus, found in-service problem. And then I'd ask for an informal conference.
Yeah.
And just say, hey, look, this is what the C&P examiners say. I don't understand why they're denying it. Hopefully you get them to turn it around there. All right. So,
and remember, if you do this within 30 days of the opinion, well, I guess you can't have a conference with CAR.
No.
God.
I'd want a conference.
Yeah, I want a conference.
All right. Next part of the question, part 3. Okay. Well, okay. So I think that it goes on here saying, okay, so go to the next one, basically showing deterioration as of September. If it deteriorated as of September, your increased rating is as of September. So I think you need to file a new claim for this. We're talking about the osteoarthritis, can't walk. I would be filing a new claim, I can't even remember this. New claim for increases on it.
0996.
It is on, so that's a supplemental claim.
It's a supplemental claim.
So that's what you'd file. It's
I'm sorry. No, that would be a 526 because you're asking for
an
and submit those records that show the problem that you're having and the tricompartmental osteoarthritis.
I think that is a new claim. So
yeah, and then this is just a regular claim. But then if you can't walk because of that, that's when you want to file an SMC loss of use of feet, because you're not able to ambulate. Okay.
You can't walk. You can't propulse off one foot. You can't balance. Those are the kind of things you're looking for. Again, as we talked about earlier, let's get a statement from you on this, what you can and can't do without a walker or a wheelchair, a statement from somebody's hopefully that can see you on a daily basis.
And this would be a 526 as well. Remember, these are supposed to be inferred claims. They are never inferred by the VA. You have to file a claim, and they don't actually have a particular form for SMC. So you just need to use the 526.
Grace, should our C file contain a copy of service records? Because how do we really know what the VA actually had them? Seriously, just saying. Yes, it should. When you file a claim, one of the first things they should do is request a copy from the National Archive of your service records. So those should be in there. If they're not, then you need to reach out directly to the National Archive and ask for a copy. Do you remember what that form's called?
No, but you're going to ask for a copy of your service medical records, and you're also going to ask for your military personnel file, because a lot of times the service medical records aren't there because they've lost them. But a lot of times the military personnel file will have either maybe the entrance and exit exam and a few medical records. So if the records are lost in the service medical file, they may still be in the military personnel file. And for some reason, the VA does not automatically order that. So you have to ask St. Louis to send that to you. When St. Louis sends it to you, they're supposed to put it in the C file, but I never know. So I go ahead and resubmit it myself.
Find your focus, 1 of 2. When already at SMCL, will 2 SMCKs bump you to SMCM as mentioned in 38 CFR statute 3.350 F3 and F4 for half steps or whole steps? Gosh. Oh.
If I'm at SMCL, when using PTSD 100% for the aid attendants, adding Meniere's 100% and Bowel constant bump me up.
Yes.
Wow. Yes.
I don't know what the Ks do there. If you do get bumped up to SMCO, then you're right. You would be eligible for R1 because you have an AA. Great on you.
Great on you.
This is good. I don't know what the SMCKs do. If it says it in there in that regulation, then I'd fight for that.
I don't know what they're for. That would be really important. Say it's loss of use of both feet. and you have an L, then, and you haven't used that for any of these others, then that would be an R1 just there.
Yeah,
So
because the two losses of beats to those two Ks equal an L.
Right.
Wow. Yeah, you need to keep
Good
fighting.
on you.
Yeah. Tony, greetings and thanks for all you do. I'm 100% P&T plus SMCS for 50% in 230s. Any update on Barry B McDonald? So at this point, to be eligible for the half steps or the full step bumps and special monthly comp, you actually have to already have SMCL, aid and attendance. So you need to be there before you can start getting half steps. So SMCS is not going to qualify for that.
Right.
Ream 86. My son applied for a caregivers program. Would the assessment process info gathered qualify me for aid and attendance under VA due to my limitations? I need help with every other living thing. If that is due to a service-connected disability, then I would say yes. But remember, these programs are under two different auspices of the VA. So the caregiver is under the Veterans Health Administration. That's where he's applying. You would need to apply under the Veterans Benefit Administration, where you've applied this whole time for VA benefits. So if you feel that's the case, then yes, apply though, because they're not going to automatically do this. But that's great evidence of frankly, one should prove the other. It doesn't always happen that way, but yeah, make sure you get that evidence and submit that too. Obi-Wan Kenobi, good to see you. If my CMP examiner's notes were favorable, but they selected less likely than not, what would be your course of action to correct the situation? First, good on you for getting the CMP exam and not believing what the rater said it is. This is a case where I would file a higher level review, like we said just a minute ago. You can't ask, well, you can't ask for a car, but I would want an informal conference, and I would just be reading from the CMP examiner saying, hey, look, he said this is connected. The rater said it wasn't. What's the problem here? Can we correct this?
Or the examiner, it says the examiner's notes were favorable, but they selected less likely than not. So from some reason, the examiner was the one that said that.
Yeah, you might end up having to get a new exam.
Yeah, and I would say a duty to assist, because it's unclear. It's confusing. They really weren't clear about what happened.
That's going to be a new exam.
Yeah.
Stephen Foster, is a CMP exam a good or bad sign? It's just
nothing.
Yeah, it's just par for the course. It's just part of what they do.
Yeah. How can I delay making a decision in this case? Oh, here's good evidence. CMP is called for.
City Knights, what happens to Q claims under and over 20 years when the disability may have improved some over time?
Well, they have to go back and consider you at the time that they made the mistake. And that's in effect. And then I don't know under that whether they'd be able to change the rating depending on what happened.
You can do a stage rating.
They could do a stage rating.
So what the questioner is asking here is that if you have a rating, if you're service connected and have a rating for 20 years, that rating is permanent and it's guaranteed.
Right.
But the question is, if you go all the way back and you get service connected for something, they give you initial rating, that they can do what's called a stage rating, meaning they go back and they look, okay, you were this bad here, you're that bad here. What you can count on for permanent, I believe, is whatever the lowest rating they gave you.
Mm-hmm.
So if that, if you had at least a 10% and they went to 50 and they went to 30 and then maybe back to 10, but over a 20-year period, then that would be guaranteed. That takes them time. A lot of times they're too lazy to do that.
Yeah, they just give you whatever it looked like back when you started.
Clayton, hey, glad you guys help us. Just got 100% P&T.
Good for you.
Have 2 claims, higher level review. Is it worth fighting? Hemorrhoids and sleep apnea. Carol's going to say yes if the P&T on the 100% was for one disability, because
that gives you SMCS, another $300 to $500.
So yeah, if your 100% P&T is combined of a lot of different issues, I don't know that I'd fight that, but Carol's right. If it is one issue, then yeah, it's worth going for to get.
And the problem is these conditions don't get better. They seem to get worse with time. Ultimately, a lot of people need aid and attendance, and then you're going farther up the SMC ladder. So I figure if you're entitled to it, do it now. You're not actually appealing what you got permanent and total for. That's a separate. It looks like you're filing for 2 things that had nothing to do with that. So it shouldn't affect your permanent and total 100%.
Karen, good afternoon, everyone. I'm Karen Shelby, and I would like to know if the BA can be used for leaving disc in my neck, maybe soothed relieving disc in my neck when they initially performed cervical spine surgery. So that would be a what's that,
1151.
So that would be a medical malpractice case against the VA. You can file that. You can do one of two things. You can ask for service connection for it. So it's like getting service connected for a VA mistake versus what happened in service. You can also file a lawsuit, federal claims action, or FTC, federal tort claim, in federal court on this. Tough cases. Those are hard to win. The case against the VA in the service connection realm is a little bit easier, but you still have to have a doctor saying that the VA
There is negligence.
committed negligence.
The federal court is really expensive,
And real tough.
really tough. A lot of these judges are very conservative. You have to have a doctor come in and testify that this other doctor was negligent. That costs a lot of money. I just think they're really hard.
Yeah.
I think that trying to get the negligence through and then get a service, and if you get, remember, if you win both, there's an offset. So you don't get to keep both sets of money. So I think usually I would recommend, unless it's really egregious and really apparent, I would think you would try the negligence asking for service connection from the VA.
I'd agree. John, never went to sick call out of service over 20 years ago. VA diagnosed me with GIRD, ED, and migraines. I use 70% mental health. Should I go after GIRD, ED, and migraines? Thanks.
I would.
I think it's related to service. I mean, I would.
Well, the migraines are probably related to the mental. The erectile dysfunction is clearly related to the mental. I mean, I even get that from all the examiners, or most of them. So, and GIRD, there's a new GIRD regulation that makes it look like it's going to be hard to get more than 10%. But if the medication you're taking caused GIRD, I would go ahead and get it. Because remember, the first thing you're looking for is 60% to get the SMCS. And if you get 50 for migraines and 10 for GIRD, that ought to give you the 60%. Erectile dysfunction does usually not give you any rating because you're paid under the SMC. That's like $130 more on top of the 100%.
Cardell, I've been denied for hypertension. A month later, I went to a scheduled appointment with my cardiologist and found out that I have 60 to 65% of heart function. Should I file a claim for hypertensive heart failure instead of appealing the hypertension?
No.
You still need the hypertension to
Right.
be service connected. Once that's service connected, then you should secondarily receive that. That being said, I'd go ahead and file for the hypertensive heart disease now. And so you have both appeals going. They're just going to deny that flat out and say, well, you don't have hypertension service connected, therefore we're not going to give you the benefits. But what you're doing is protecting the effective date on that hypertensive heart disease.
And that's what I do with a lot of my clients. I will file a lot of claims that I know are going to be denied, but I want to get that effective date. And then when we get service connected, this is why it's frustrating for them. Sometimes they just see these rating decisions sitting there. Well, if he's not service connected for hypertension, I don't want to appeal the hypertensive heart disease. I'm going to let it sit there, and I'm going to work on getting him service connected for the hypertension. And then when I appeal hypertensive heart disease, it's going to flow.
But you're still going to appeal the hypertensive
I'm
heart
going to
disease
appeal it, but I don't do it right away.
Right.
Because I just be denied. And then,
Right.
then the BVA has this new thing that if you go to the BVA and you're not service connected at that time, they only look at what's, I don't think this is correct, but this is what they're doing. They're saying, I'm going to look at the rating. I'm going to look at your case at the time this appeal was filed. You weren't service connected for hypertension there, even though you are now. Therefore, we're denying service connection for hypertensive heart disease. So that's why you have to get the claim filed, but then sometimes you're slowing up the ones that you know are waiting for another decision to be, another rating to be, disability to be granted, and then you push the others. But always file. I got this sign that I stopped bringing. Always file.
So what's to understand the numbers here? Again, hypertension, you're going to get a 0 or 10%. Hypertensive heart disease, you get a 60, you get 100%. And if you wait for that hypertension to be service connected, then file the hypertensive heart disease, you've probably been a year, 2, 3 in the system for hypertension, and then you don't get benefits until the day you file that hypertensive heart disease. So that's why you want that in the system.
Right.
Wayne, 100% P&T. VA sent me for a C&P at the VA for hearing loss increase filed before 100% examiner read words in her microphone so I could hear them, and then gave me a test that I couldn't hear. Thoughts?
I'm not sure what he's saying.
I don't know that I want hearing loss anymore. I mean, if you're maybe deaf, then maybe we go for that, but I don't know what that's going to do for you to give you a higher rating.
Problem with hearing ratings is the VA is, I mean, their rating system is getting a 0 or 10% is as much as you get unless you are really deaf. And I'm
you're
talking
servicing
about,
it for both ears.
yeah, and you have to be, I mean, really deaf. When my clients can't hear me on the phone and they have an amplified speaker, then I know they're entitled to a really high rating. But other than that, you're just wasting your time. You'd be amazed at how deaf you have to be to get a sensible rating. And the thing about, I had one guy I'm appealing right now, he had hearing loss. He is very, 20%, 40%, 40%, 50% over the last 10 years. He just had another CMP exam, and guess what? He has perfect hearing, 0%. So these hearing loss claims are just really difficult.
Mm-hmm. I'm just thinking quality of life. If the hearing loss is annoying, bad, but not awful, like Carol's saying, I just don't know that you want to be dealing with that if you already have 100% and you can just get out of the system and not have to deal with the VA.
Right. If you have, it's crazy because tinnitus, as long as it started in the service, due to a service-connected problem, started in the service, you get your 10%. But hearing, you have hearing aids, you can't really hear, and you still can't get 10%. So I'm just telling you, that's one of the disabilities that really frustrates me, and I'm not sure what to do because of how crazy they are. I mean, 20 years, this guy has had 40% back to like 16 years, 50% for the last 10 years. Now that's wrong, and I'm going to get that reversed. But I'm just telling you, it's, 0%, really?
Richard Unknown. I had an unknown third party file a fiduciary with the VA. How do I get the fiduciary claim to go away? Wow. Well, I mean, if the VA finds that you are incompetent to manage your funds, they bring in a third party to do that. So that's probably what happened here. And if that's the case, this is a longer road to figure this out. I mean, you need to appeal and you need to say, I'm competent to manage my funds. Then you need to have some evidence to that effect. Evidence could be that you never, bounced a check or you've never missed a credit card payment.
Your credit rating.
Your credit rating is good. Or that your spouse was the one that primarily handles all this. And so this hasn't been something that you've handled and therefore they have no basis upon which to take away, your, or assign away your ability to,
But before
finance.
any fiduciary was appointed, they had to have sent you a letter saying, we're proposing to find you incompetent. They had to do that. So, but the problem is, I don't know how this could even have gotten in there. And then once they propose and find you, then it's taken out of the VA system and it's sent to this separate office that's just fiduciaries. And that's really hard to get a hold of and figure out what's going on there. But I would file an appeal if you never had proposed, they never proposed to find you incompetent. Asking you to find competent and asking how in the world a fiduciary was appointed. Remember, you need to file it on a claim file or 4138 or something they have to respond to.
Jason, if a veteran's 100% P&T for PTSD, should they file for homebound? If so, will that open VA to reopen everything and possibly lower their percentage? Thank you.
Well, I'd like to know, first of all, how long have you had the 100% for PTSD? Because those are ones that they don't like giving you that much money. If I think the evidence is fabulous, then I wouldn't worry about it. But
you're going to be reevaluated if you open a claim, because basically you're saying my claim should be rated higher, and the way the VA looks at it, they say, okay, well, it should be rated higher, it could be rated lower.
Because from all you're telling me, the only disability you have is PTSD. So they're looking to see if the PTSD is keeping you homebound. So that will be reevaluated. Say you were filing for homebound because of another condition, then I wouldn't worry about the PTSD because then that's not something you're appealing.
Tiny, good to see you. Shouldn't the examiner take into consideration medications for disabilities for primary disabilities? Depends. Some of the diagnostic codes specifically state problems with medication versus without. If you're talking about problems that the medication itself causes, like ED is one that can be a problem due to some medications. GIRD can be a problem due to some medications. That's
Sleepiness.
Sleepiness, yeah. So it just depends on what you're saying there. I'm not sure.
But most of the time, yes is the answer.
Yeah. Thomas, sorry for being cut off, but how do I go about getting rated for GIRD? I have 3 esophageal procedures since 2020. You need to look at the GIRD rating and the diagnostic codes. Nate is not with us today. We have Claire and Benji who've replaced him behind the screen. If one of y'all could put up the VA diagnostic codes link so that Thomas here can go find that. But you need to see what the diagnostic codes say and fit in your evidence with that and submit that as a supplemental claim.
And I'd like to know what the esophageal procedures have been. Sometimes people have them because their throat narrows, and that's not GIRD. That could be something else, and that could give you benefits aside from the GIRD disability. Okay. The other thing is the new ratings, the new regulations on GIRD. We haven't really seen a lot of action, so we're not really sure what they're going to do with it. I'm just telling you, reading it, it looks like it's not very favorable.
Margaret, for 100% P&T with SMC working, is there a maximum amount for wages? If you are 100%, there is no prohibition against working.
100% for one thing, not 100% under unemployability.
Right. Or 100% on combined ratings of several issues. So there is no cap on wages. If you're 100% for mental health, they will look at your occupation and think, well, if you can function in a occupational setting, or you should really be 100%. But otherwise, you can work away as long as it's not unemployability. The best of us. I am 100% P&T with 70% mental and all others with no hope of getting better. Can I get downgraded?
You can always get downgraded. The VA always. Now remember, if you've had permanent and total 100% for 20 years, then the answer is no. But other than that, neighbor calls in and says, this guy's out doing whatever you shouldn't be able to do with your disabilities, then they will re-examine your case. We've had that happen.
This is where I prefer my vets to stay out of the system, not file any other claims like tinnitus or scars or something like that.
No, this is a guy he hadn't filed anything.
So yeah,
it was a neighbor that.
Oh, right. Well, no, in your situation, what I'm saying is the farther you stay from the system, the better you are. If you start asking for more benefits, they'll re-examine you. But if you're permanent and total, that means they shouldn't be sending you in for re-examination. Doobie May in the G. Good afternoon, team. Currently at 90%. The driver of my disability rating is due to my anxiety. Will the VA ever reach out, go up for a following C&P exam for anxiety and potentially lower my disability? As Carol just said, that can happen to anybody.
Yeah.
So what does this mean? When you go to the doctor, you got to realize your notes are going to be reviewed by a third party. So when the doctor says, hey, how are you doing today? You don't say, oh, fine, doc, how are you? You say, this is what my day looks like. This is my past week looked like since I've seen you, X, Y, and Z's happen. You lay it all out there and make sure the medical records accurately reflect what you're going through on a day-to-day basis.
Because I find sometimes I will know that the VA has looked at that paperwork and decided not to reevaluate. I'm looking at the VA record. They're going to mental health. They're still having a lot of problems. They give it another, what they call it is EP. What is it? Evaluation it's a date. Even if they put a person, since you're not permanent and total, even if they decided to give you another exam, a lot of times they will look at that and say, the person's still, I'm not going to send them out. And then they'll just make it permanent and total, a lot of them. So what you're saying can make a big difference in when you're evaluated.
Kenneth, do constantly calling and going online to check your claims slow the claims down? Going online doesn't affect it all. I mean,
no.
If you called your congressman, that would definitely slow it down because they have to write a report to the congressman, but otherwise it shouldn't slow it down. Private Johnson, I'm at 90% was tonight when my percentage was lowered for TDIU. Do I reapply with my 70% recent diagnosis? I'm 70% now without the PTSD diagnosis.
Yes. Remember, for unemployability, you just have to have one rating that's 60%, one disability that's 60% or more, or a combined rating of 70%, where at least one is 40% or more. So you meet that. And I would wonder what your PTSD was lowered to.
Was denied TDIU and my percentage was lower. I'm now at 90. How do I reapply for the 70% for PTSD?
Oh, I see. Remember, once you have 70% for a mental condition, the VA is supposed to, and you're not working, the VA is supposed to automatically consider whether you're entitled to unemployability. So you have a much better chance of getting unemployability now that you have that 70%. So absolutely, you should reapply.
Yeah. You file what, a supplemental claim for that?
Well, if it's been more than a year, you'd file a 526.
Okay. Past futures, been waiting for an audit request to be moved past the third step since March 24, called twice, once in October and today. And they said there's nothing I can do. What do you suggest? I find these audits take forever.
Yeah.
It's just something they don't want to do. And I don't know if they don't get work credits for it or something, but I don't have any.
We wish we
advice.
did. We have a lot outstanding.
Juliet's got 100% P&T, SMCS, housebound. Can I be cut back? One rated 60%, several smalls, totals for 340%. I am heart failure.
Heart failure, you should be 100% just for the heart failure. And if you have heart failure, have you filed for aid and attendance?
Mm-hmm.
So I would definitely remember under the, what's the name? I was just reading it. Barker, the one that you get all the SMCs. Barry. Remember in the Barry case, if you get, looks like you have a bunch of different ratings. If you get aid and attendance and you got 100% for one condition, then you can use these other 50, 100% to move on up the SMC ladder. So I would definitely, your permanent and total heart failure. If you got heart failure, I wouldn't worry about appealing this. I would go for aid and attendance.
Wait, you wouldn't worry about being reduced? Is what
No,
saying.
heart failure is 100%.
Yeah. So she's saying she would appeal it. She wouldn't
Yes.
worry about being reduced on the appeal.
Hey, tenacious. I like that.
I was denied for chest pain. CMP showed left aurial enlargement, favorable findings, chest pain complaint with chondritis diagnosis and service.
Is there more?
I don't know what the CMP examiner's conclusion was here. If the conclusion was favorable, then that's to me obvious higher level review appeal to get within a conference to have it overruled. But if the CMP examiner finds all this, but then on top of it just says it's not service connected, maybe it's a higher level review for duty to assist because the findings don't match the conclusion.
Well, costochondritis is not a heart problem. It's when you have pain in your chest, but it's not related to your heart. And a lot of times when people have chest pain, they think it could be costochondritis. So if that's what you really had in the service, that would not help you get service connection for a heart problem. So you really need to look at your service connected problems. Did they take an EKG that showed any heart problems on there? Or I'd like to know what was in the file. I'd like to know what your complaints were.
James, diagnosed with hyperparathyroidism and had it operated on. 3 deployments to burn pit areas. Is there something I can get the VA compensated for? This would be a Terra, probably, right?
Yeah.
So you need to tell them I was in burn pit areas, ask for a Terra memo, which would basically say what toxins were released by those burn pits and could that have caused this disease. Gerald, hi. I'm waiting for a video hearing with the VA judge. How long is the wait? Got my
How long you got?
In August this year. They're not giving. I mean, hearings are the death of veterans. Unfortunately, I mean they're not required by law to let you know how long it is. We've seen 5 years, 7 years from the date of the appeal.
And then once you have the hearing, it doesn't mean they're going to make a decision. We have people that have come to us. They've already had the hearing and they're waiting 2 or 3 years and they still don't have a decision. We can't tell you enough. The hearing, I don't know how a hearing can help you. They're supposed to make a decision based on the written evidence. So they love to get rid of these hearings. So if you want to, you can file a request to waive the hearing and go on the record. Remember, if this is under the AMA, then you have 90 days after that to submit any additional evidence. Okay. But please don't
Well, it is what it is.
Yeah.
You're in the back of the VA decision bus, BVA.
And for some reason, VSOs think they're helping you by asking for this. But even the judges, every time we go to the conference and they speak, they go, please don't ask for a hearing. You're going to wait forever. And it doesn't make, they try to tell you, it doesn't, what you say, the only thing they can decide is whether you're credible or not.
Which is usually against you.
Yeah. So how does it help you to have a hearing?
Serge, if my attorney is sitting on my claims appeal and other claims, can I switch attorneys? Yeah, I mean, you can always fire your attorney and ask, try to get a new attorney, but that first attorney has to withdraw their fee agreement. If they don't agree to that, it's going to be pretty hard to find another attorney. Before doing that, I would ask why your attorney's sitting on the appeals, because Carol said she does that sometimes, but that's her strategy. So, I would just check with this person first. They're a qualified VA, their attorney, they could have a reason why they're doing that.
I mean, it's so complicated that, there just a lot of times I let others sit because I know how they're going to interact with the other claims that are pending, or I'm trying to get additional evidence like an independent medical exam. And you just can't get those like that if you want a good examiner.
Yeah.
You have to get in line, get on there. You have to get the medical records. You have to get in line, and you have to get an appointment date from them. That can take a long time, but that's how we win the cases. Mm-hmm. So there could be many reasons why the claims are sitting there. I really think you should ask your attorney why.
Right. They owe you an explanation.
Right.
Just don't automatically assume it's bad intent on their
part. Right.
Daryl, I was stationed at Camp Lejeune in '85. I was recently diagnosed with prostate cancer. Can I file a VA compensation under the PACT Act? Yes, you can. Cheryl, hi again. Listen to you guys every week. I'm 10% for tinnitus, 30 for heart, denied back, sleep apnea, waiting to submit evidence to a VA judge hearing. What are my chances trying to reach 100%? Depends on how bad your back is and what secondary problems. Do you have problems with incontinence? Do you have problems with radiculopathy in your legs or your arms? Sleep apnea, if you win and you have CMP, that's automatic 50 right now. So I don't know.
And remember, they're proposing to reduce the sleep apnea to 0%. So right now, I don't know that you get a combined 100% with what you're showing me. If the sleep apnea, the new sleep apnea rules have come out and they do give a 0%, because for your back, you're lucky if you get 40% for a back is amazing. And then you want radiculopathy for both legs. Is there a problem with that? So you can get pretty good ratings for your back, but it has to be pretty bad. And, the thing you should look at is they probably did a CMP exam when they denied your service connection for your back. What rating would you get if you win? Because they're going to go back to that and say, hey, you had a 0% for your back and nothing for your radiculopathy. So you really need to know what evidence in the file. I definitely, whenever you have a back, you want to make sure that you have good evidence, because if you win and you get nothing, you spent years getting nothing. So you really need to make sure that it shows radiculopathy. It shows you're very limited moving forward if you are bending over to touch your toes. Those are things people don't look at. They just look at getting service connected, and then they don't understand where that's going to leave them if they have bad evidence in the file for the rating.
All right, let's do 3 more here. AJ, hello, I'm 80% now. I had a CMP a month ago for mental health and got deferred and got a CMP for PTSD. Still waiting for this. Is this favorable on my side? Again, it depends on what CMP said. It depends on what the adjudicator asked the examiner to either elaborate on or give an answer on. You can request your CMP exam, and what do you have to do to request the notes from the examiner?
You just have to call the VA and ask them for a copy, or send in a 4138. Say, please give me a copy of the CMP exam for PTSD that was held on this date. And you get those pretty quickly.
So that will give you the answer.
Yeah.
Virginia, can your VSO refuse to help you if you also call the VA 800 number for claims questions and make a VERA call for appointments? I mean, they can do whatever they want. Might need a new VSO if they're saying they don't want you to do that.
Remember, there are a lot of organizations.
Yeah.
Each state has one. You have DFW, counties have one, DAV. I mean, there are a lot of them. So if one isn't helping you, go to another one. I don't know what their rules are.
Yeah, I don't either. Colby, hey guys. Currently rated for hearing loss and tinnitus. I have an ACE exam scheduled for today for 5:30 for migraines claim. Is it common they call?
Yes, lately they have been doing a lot more calling because with migraines, they don't have to physically examine you.
Right.
They're asking you questions. And that's why you get that DBQ, Disability Benefits Questionnaire, and look it over. But remember, there are only 3 questions that matter. The whole front part, whole couple of first pages talk about, do you have pain? How often do you have the migraine? You know, a lot of questions like that. It makes it look really bad. But the questions, do you have at least once a month? Secondly, do you have to prostate? Who came up with that word? That means lie down. So if you have to prostate, that's a 30% rating. And if you can't work, if it causes economic problems, then you get the 50%. So for economic problems, you have to talk about when you have a migraine. So I would look at those questions and make a list. I have migraines 4 times a month that cause me to go home, lie down in a cold, dark room until I fall asleep, and then when I wake up, I feel a little bit better, but that's usually 3 or 4 hours later. So I miss work 3 or 4 days a week. I cannot concentrate. I cannot be around sound, noise, or light. For instance, when you have migraines, that's usually what the problem is. So those are the 3 questions you need to make sure you're ready to answer.
All right, folks.
Second, just one more thing.
One more thing.
And then you want a copy of that CMP exam, because somehow I have found over and over again, although my clients may say that because they tell me what they say, they get 10% because they say, nope, they don't need a prostate, and nope, it doesn't interfere with their ability to work. So you need to contradict this if this is what you find. Don't take it for granted. They're going to write down what you say, because they don't. Sorry.
Thanks for joining us today. We appreciate all the questions. Love seeing the insight that you guys already have as far as having looked at CMP exams, looked at regulations, understanding what you're entitled to. Remember, don't take the denial at face value. If you feel like you're entitled to these benefits, keep fighting. Until next week, have a great day.